Guys, and welcome back to Law Talks with Martin. In today's video, we'll be talking about law of contract, the basics. What a contract is, the necessary elements required for a contract to be valid and be formed. So let's get started. What is a contract? In simple terms, a contract is an agreement between two or more parties that is legally enforceable. It creates rights and obligations that the parties must fulfill. It's an agreement between two parties that creates an obligation to perform or not perform a particular duty. So there are different kinds of contracts. You have the formal contract, which is written, signed, and sealed. The seal is very important in a formal contract. This kind of contract is usually attributed to land matters. You have to have this in place when you purchase land or a house or any kind of property. We have simple contract, which means any contract other than a formal contract, and it doesn't have a seal. It could also be oral. Then we have express contracts whose terms and contents are clearly and explicitly stated and agreed upon by both parties. And then we have an implied contract whose terms are not expressly stated but come into existence by the conduct of parties. So if, for example, every day you wake up and go to the woman who sells akara and buy from her, every morning she sees you at a place, she already knows what you want, and you probably don't need to tell her the amount of akara you want. She already knows, hence the referral to conduct of parties. We have bilateral contracts, which involves exchange of promises to do or refrain from doing something. You promise to do something for me and I promise to do something in return. Then there is a unilateral contract, which is an exchange of performance of an act in return for a promise. I promise to give you something in exchange for you doing something for me. Once you do that thing, I must fulfill my promise to you. When it comes to forming a contract, the 5 key elements needed are offer, acceptance, consideration, intention, and capacity. Offer and acceptance, we'll treat that first. A contract begins with a clear offer by one party and its acceptance by another party. Both the offer and acceptance must be communicated explicitly. For example, I'm offering you to sell you my scarf at the cost of 1,000 naira. You accept and I give you the scarf in exchange for the 1,000. That 1,000 you gave me is called consideration. A valid contract requires an exchange of something of value between the parties involved. This is known as consideration, which can be in the form of money, goods, services, or a promise to do something. Then we have intention. This is a person's awareness of and willingness to comply with the terms and conditions of a binding contract. The parties involved must demonstrate a genuine intention to create a legally binding agreement. There are times people weasel out of their obligation and say that they were joking when they entered into a contract. And this is why when forming one, you should ensure that the other party has a proper intention with all seriousness to form that contract with you. And then we have capacity. Capacity to form a contract is the legal ability or competence of a person to validly enter into a contract. All parties entering into a contract must have the legal capacity to do so. This means that they must be of sound mind, of legal age, and not under any legal incapacity. There are certain people that lack the legal capacity to contract, such as illiterates. For illiterates, the issue arises when it comes to written contracts. And illiteracy here doesn't have the same definition as in a dictionary. Illiteracy here is based on a person's knowledge of the language that was used in the course of negotiating the contractual document. So when it comes to illiterates, the document must be fully explained to them in detail until they understand it for the contract to be enforceable. We have minors. When it comes to minors, anyone under the age of 21 with regards to a contract is considered an infant and incapable of entering into contracts unless it's of necessary goods. We have lunatics. These are people who are of an unsound mind. And then drunkards. Intoxication can be a reason for getting out of a contract, provided the other party was aware that the first party was intoxicated. Now we have unincorporated entities. These are registered companies. They can't sue or be sued or enter into contracts of the company. When entering into and terminating a contract, it is essential to seek legal advice to ensure compliance with Nigerian law and protect your rights and interests.